Deputy Crown Solicitor and Chief Counsel at Crown Law, and I warmly welcome you to this online AACL panel event to discuss the recent High Court decision of the Minister for Home Affairs in Benbrika, which considered the validity of preventative detention scheme directed at those convicted of terrorism offences. I'd like to begin by us acknowledging the traditional custodians of the land from which we're streaming today's seminar. So we pay respects to both the Gageler and Turrbal people and their elders past and present. Given the reason why we're meeting today, it's also worth pausing to remember that they are the lawmakers of the oldest continuous legal system in the world. By way of overview of this evening's proceedings, tonight we're incredibly fortunate to have with us two esteemed constitutional law experts, Dr. Rebecca Ananian-Welsh and Felicity Nagorka, who'll be speaking to us to discuss this decision. I'd also like to let everybody know that this evening's seminar is being recorded, and I'd also ask that you remain mute throughout the recording. We will hopefully have some time for some questions at the end of the discussion, and you can ask the questions probably most conveniently using the chat function on your computer. So over the last several decades, the criminal justice systems in all of the Australian jurisdictions have really battled with the vexing issue of how to protect the community from dangerous offenders and their potential for reoffending. That issue, I think, has been exacerbated by some highly publicised incidents of particularly sex offences involving violence or against children, and growing community concerns over fears for community safety. Likewise, the risk presented by terror offences is a growing community concern, and in the decision of Benbrika it was described by the court as a singular threat to our community. The principal objective of preventive detention legislation is not further punishment of the offender, but the protection of the community. We see this objective used in a number of other social policy contexts, including the mental health field, and to prevent the spread of infectious diseases. Turning to the case at hand, Mr. Benbrika was the first convicted terror leader in Australia, and he challenged his detention beyond his sentence under the Commonwealth post-sentence preventative detention scheme, which was targeted at high-risk terrorists, and that scheme only came into effect in 2017. So Mr. Benbrika was convicted in September 2008 by the Supreme Court of Victoria. He was convicted for being a member of a terrorist organisation and also directing the activities of a terrorist organisation. He was one of about 13 men who were charged in the same investigation, and he was alleged to be the alleged spiritual leader of the group. Most of the evidence against Mr. Benbrika comprised of phone records, which revealed plans to cause maximum damage and to cause the death of 1,000 by use of a bomb. The prosecutors alleged that Mr. Benbrika was bent on violent jihad and that the group had planned terrorist attacks on football games or train stations to maximise deaths, including some discussion on bombing the MCG during the AFL Grand Final. In some cases, Mr. Benbrika said it was theologically possible to kill women, children and the elderly. He was found guilty on the charge of intentionally being the leader and a member, and was sentenced to an effective term of 15 years imprisonment with a non-parole period of 12. His full-time release date would have been November last year, but the federal government successfully sought to keep him behind bars because they believed he continued to pose an unacceptable risk to the community due to his violent ideological beliefs, coupled with antisocial personality traits. In December of last year, it was ordered that he be subject to a continuing detention order which is enforced for a period of 3 years. That order was challenged in the High Court, and it was argued that the law was invalid, and essentially that it was punishing him for what he might do, not for what he had done. In February this year, a majority of the High Court found that the law extending his detention was valid, and also that preventive detention for people who may commit terrorist offences is just like other exceptions, such as detention of those suffering from mental illness or infectious disease. It's interesting that the Commonwealth scheme, which was under consideration by the High Court, drew very significantly from existing dangerous offender regimes that we see in other jurisdictions, most notably the Queensland Sex Offender Scheme, which is the Dangerous Prisoners Sexual Offenders Act 2003, which represented the first successful attempt at a legislative scheme to detain a class of people on the grounds of dangerousness after the offender's full sentence had expired. That scheme allows for continued detention as well as for supervision in the community. So that legislation was upheld in the High Court in Farden and the Attorney General 2004, 210 Australian Law Reports 50, and it's been used as a model in other jurisdictions, including as a model for the Commonwealth legislative scheme. It won't surprise you to learn that such legislative schemes carry constitutional law issues, and those issues continue to come before the High Court. Those issues centre around whether the decisions to deprive individuals of their liberty under continuing detention schemes are incompatible with the concept of judicial power as set out in the Commonwealth Constitution. The recent decision of Benbrika represents the first consideration of whether a state court exercising Commonwealth judicial power can impose detention, which is not for punishment under the criminal justice system. I will very shortly hand over to our first speaker, Dr. Ananian Welsh, but first I'll give you a very brief introduction. Dr. Ananian Welsh has a particular interest in terrorism and Chapter 3 of the Constitution. She is a constitutional law scholar and senior lecturer at the University of Queensland, and she has combined expertise in courts, national security and press freedom. She has previously given evidence to the Parliamentary Joint Committee on Intelligence and Security, and she's contributed to numerous submissions to government with respect to national security, human rights and constitutional issues. Prior to her outstanding career in academia, she was a litigation solicitor at DLA Piper and also a legal officer with the Federal Attorney General's Department in Canberra. So we'll link over now to Dr. Ananian Welsh.
Thank you, Patrina, for that fantastic introduction. I'd also like to acknowledge the traditional owners on the land on which we all meet or zoom in from today, and to just take this opportunity to express my support for the Uluru Statement from the Heart, and in particular for a constitutionally enshrined Indigenous voice to Parliament. I'm going to attempt to share my screen with you now, so give me a minute. There we go. Okay, so hopefully someone will tell me if that didn't work. So Patrina's done a fantastic job of outlining what this case is about, this challenge to continuing detention orders. I'm going to give a little bit of a summary of the case, but also try and place it in the context of terrorism law more broadly. So this year, in September, we will be commemorating 20 years since the September 11 attacks. And in that 20 years, terrorism and terrorism law have evolved a long way. So you probably have heard, because it's often been observed, that Australia in that 20 years has gone from having no counter-terrorism law at national level, so zero laws that mention the word terrorism, to now more than anywhere else in the world. That's in excess of 80 separate pieces of legislation enacted in the last 20 years. Not only has terrorism law evolved, though, but terrorism has evolved. So the September 11 attacks were a highly orchestrated, well-funded, organised, large, huge-scale event. More recent kinds of terrorism attacks, and it's not like those ones don't happen anymore, but we have other things, and we've got a picture there of from the Nice Bastille Day attack, where a young man hired a truck and drove it into a group of people, and the Westminster Bridge attack, where someone picked up a kitchen knife and started stabbing innocent bystanders on the Westminster Bridge. So terrorism has evolved. It still presents this incredible risk, and these low-tech, low organisation, often prompted by cyber radicalisation kind of new faces of terrorism, can be a lot more difficult to control and to respond to. So one of the issues facing government is once it identifies somebody, whether they be in the community or in a prison or anywhere really, who presents a risk of committing a terrorist act or a risk of terrorism, what do you do about it? Well, the good thing about having 80 plus counter-terrorism laws is that we have a whole bunch of things we can charge them with. So there are offences around advocacy. So just talking about it in a certain way can be enough to land you in jail for a terrorism offence. Possessing a thing connected with terrorism is an offence. We have a preparatory offence, so preparing or planning for terrorism is an offence. Making a document in connection with a future unspecified terrorist attack. We also have a vast suite of terrorist organisation offences, and they're just the tip of the iceberg, really. Adding on to these and extending them is the usual inchoate liability provisions at the front of the criminal code. So conspiracy to do an act in preparation is a terrorist offence that a lot of people have been charged with, and you're looking at sentences of around 20 years if you're going to get done for conspiracy to do an act in preparation. But there could be attempt to make a document, conspiracy to possess a thing, very broad offences. But what if you can't charge that person? You know that they're a risk, but you can't charge them. So we have, for example, here in the middle, Man Monis, who we all know, especially as constitutional lawyers, was no stranger to the legal system before he held up the Lindt Cafe in the infamous Lindt Cafe siege. But he hadn't been charged with any kind of terrorism offence by that stage. So what can you do with those people if you haven't quite met those conspiracy to do an act in preparation kind of standards? We have other things. So we have police powers around preventive detention orders. People can be detained, incarcerated for up to 48 hours, but that's only to prevent an imminent terrorist attack or to respond to a recent terrorist attack in order to protect evidence of that recent attack. We have enhanced intelligence powers around surveillance and metadata collection. But one of the key things that was introduced in 2005 are control orders, and that's a civil order that can impose a vast array of restrictions and obligations on a person for the purpose of protecting the community from terrorism. That person needn't have committed an offence. It's a purely preventive, protective kind of order. And that's critical to mention, I think, here, because it was in 2007 that the High Court, by slim majority, upheld the power to make control orders, which had been conferred on courts, as a judicial power. And that case comes up again in Benbrika. There's more, though. So you don't have 80 plus laws without more that you can do. There are administrative powers if someone is a dual citizen, as Benbrika is, he's Algerian Australian, then you can strip them of their Australian citizenship. If someone's here on a visa, you can get rid of their visa. If someone is here, if someone's an Australian citizen and they're here, you can stop their passport. If they're overseas, we have something called a temporary exclusion order, which can exclude the person from returning to Australia on the basis of community protection and risk of terrorism. So there's all these things that we can do. But in the absence of a charge, can we put one of these risky people in prison? So what you may be thinking is, oh, like we do for sex offenders. So in the states and territories, this idea that you can have people who are at high risk of or unacceptable risk of committing a certain kind of offence, a heinous offence, we can put them in prison or we can keep them in prison. And we've got in the states that kind of evolution of constitutional law alongside the kind of criminal community protection laws with the DPSOA, of course, which, as Patrina mentioned here in Queensland, upheld in Farden as constitutionally acceptable, which allows for certain kinds of offenders to be kept in jail past the end of their sentence on the basis of a risk assessment of future offending or future harm. Whether or not the federal government can do that raises a different set of constitutional questions. And the things that I've put up there, I think this is the government's approach to preventive detention, the federal government's approach, is really demonstrated in preventive detention orders and control orders, which I just mentioned. And the shift can be seen with CDOs enacted in 2017. So with PDOs, they're those police powers I just mentioned where you can put someone in jail, the police can put someone in jail without charge for up to 48 hours if there's going to be an imminent terrorist attack or a recent one. It's only 48 hours under the Commonwealth law. What you can see there is a kind of policy restraint. And I think that's born out of this perception of constitutional restraints. That under the federal separation of powers, it's just not okay, or the rules are that much stricter around non-judicial detention or incarceration in the absence of a finding of criminal guilt. Similarly, for control orders, we have extended restrictions and obligations up to a year. You can keep it rolling on and on and on. All sorts of things, curfews, education, kind of counselling, can't access certain technologies, can't call people, all sorts of things, short of imprisonment. And the legislation was very clear about this not allowing for imprisonment in a state facility. And that really played into the decision of Thomas and Mowbray as well. In 2017, we see the Commonwealth deciding to experiment with these state-style preventive detention schemes. They're deciding to give it a go. Now, the CDOs that have been enacted, and these are straight after control orders and preventive detention orders in the criminal code, so we're going to slide in Division 105A, were described by the joint judgment in Benbrika as comparable to the DPSOA. So we've got this idea that we're going to use this sex offender style post-sentence detention for terrorists. So let's look at CDOs. Whole bunch of words up there, but you can kind of help you get the gist of what these orders are about. The object is clearly about community protection, focusing on the prevention of Part 5.3 offences. That's your section of the Criminal Code dealing with terrorism offences. Made by a Supreme Court, so we have a judicial order, much like control orders, against adult people in custody convicted of certain kinds of terrorism offence. Serious Part 5.3 offence is the term that tends to be used the most, and that's a terrorism offence punishable by more than 7 years imprisonment. Most terrorism offences will attract more than 7 years imprisonment as a maximum possible sentence. Now, this is critical. The court, in order to issue one of these orders, must be satisfied to a high degree of probability on the basis of admissible evidence the offender poses an unacceptable risk of committing a serious Part 5.3 offence if they're released into the community. Now, every constitutional lawyer knows that these cases always turn on statutory interpretation. There was a real split on the court and a lot of attention and debate on this notion of unacceptable risk to the community, blah, blah, blah. Whether this means an unacceptable risk of them committing an offence, or whether in that term unacceptable or in a more contextual reading, that means an unacceptable risk of harm to the community through a 5.3 offence. So the risk will be unacceptable if it actually results in harm to the community. Alternatively, the dissenting judgments kind of relied on an interpretation that was just an unacceptable risk of the offence, whether or not it's possessing a document which may not actually harm anybody. One of the critical safeguards here is that the court must be satisfied there's no other less restrictive measure. The obvious thing there is control orders. So in control orders allow for such a vast array of restrictions and obligations that paired with this, it really means nothing short of imprisonment is going to prevent that unacceptable level of risk. Now, detention is up to 3 years. We're blowing our 2-day limit in PDOs out of the water. Successive orders are permitted. They're reviewed annually, and there's a range of expert reports and all sorts of factors that it can be taken into account. So there were 2 constitutional hurdles two constitutional questions for the court, hurdles for the Commonwealth in enacting the legislation. And these are particular to the Commonwealth kind of separation of powers. They don't factor in the states, so they weren't an issue for Farden. The first is, of course, the Boilermakers Rule. Chapter 3 courts are limited to the exercise of judicial powers, and that includes state courts in their exercise of federal jurisdiction. So this needs to be a judicial power. The second hurdle comes from the case of Chu Kheng Lim. And I've put the whole quote up there from Brennan, Dean and Dawson's judgment in that case, because that's kind of the off-cited, everyone goes to it kind of line. The way that this doctrine has been treated since renders it one of the most fraught, slippery, uncertain kind of doctrines, I think, to emerge out of Chapter 3 in the 90s. I guess that's saying something. So that's putting to one side exceptional cases. The involuntary detention of a citizen in custody by the state is penal or punitive in character, and therefore under our system of government exists only as an incident of the exclusively judicial function of adjudging and punishing criminal guilt. So the government, federal government, cannot put people in jail because that is exclusively judicial. And not only that, it has to be a consequence of that particular exclusive judicial function of adjudging and punishing criminal guilt. So a criminal trial. You're going to jail, you need a criminal trial. But there are exceptions. And the series of cases, there were exceptions mentioned in Lim, and the series of cases that came after Lim have really blown those exceptions out to the point that we can wonder whether or not it's still a rule. The 2 quotes there are how the court in Benbrika framed the issues before it. You can kind of see there that some of the judges bound these 2 questions up together and dealt with them kind of, do we have a valid exercise of a judicial power to detain? And others separated them out quite clearly. Is this judicial power, does it violate the Lim immunity? So in a nutshell, we have a joint judgment from the Chief Justice with Justices Bell, Keane and Stewart. And that's the real guts of the case, I guess, if we want to find findings. They said it is judicial power and it doesn't contravene Lim. Justice Edelman, perhaps predictably, wrote a very lengthy judgment, engaged in his own quite different reasoning process, but came to the same conclusion as to validity. We have strong dissents from Justices Gageler and Gordon, much along the lines that was quite reminiscent, for me at least, of their dissents in Vella last year. So for Justice Gageler, he would have held the legislation partly invalid, capable to be read down to only apply to some part 5.3 offences. And for Justice Gordon, it was wholly invalid. So let's look at how that breakdown happened. Judicial power. I would like to talk about this all night, but I'm going to be quick about it because there's not a great deal of time, and also because the court was quick about it. So this central separation of powers at federal level question about, is this an exercise of judicial power, I think is just getting less and less attention through the cases. And here it got very little attention. I've put up out of I don't know, to honour it as almost something that's gone by the wayside, Chief Justice Griffith's classic definition of judicial power from Huddett, Parker and Moorhead from which all the indicia of judicial power have emerged. The two indicators or indicia of judicial power in issue in this case were whether the decision was conclusive, sufficiently conclusive, and whether it was about a dispute about existing rights and liberties. Also, the issue of judicial process came up. As to conclusivity, look, that's a high bar anyway, and anyone who dealt with it on the court said, yes, this is sufficiently conclusive. At the time that the order is made, it is binding, it is authoritative, even though it is subject to annual review. Is it a judicial process? Absolutely. I think the government kind of learnt the lessons from post-Kable and during FARDN and International Finance Trust, and they've bedded down a very orthodox judicial process, rules of evidence, submissions, all these things. But is it a resolution of a dispute about existing rights and liberties? Parliament creates rights. It thinks about what it can do in the future to stop terrorism and protect the community and how to fix problems. Courts don't do that. They look backwards and they look at a dispute and say, right, did you breach that contract? Were you negligent? Did you murder that person? CDOs don't require the resolution of a dispute like that. They are, what can we do in this situation to stop the risk of terrorism? What can we do? How risky is this person? And what are they likely to do in the future? And should they go to jail for that? So this was definitely not fitting within the traditional conception of judicial power. However, Thomas and Mowbray really rises up and starts to bite at this point. So because of that decision in Thomas and Mowbray, which, as I said, was a 4-3 highly controversial decision, but it rests as good law, if issuing control orders over people to stop terrorism or protect the community from terrorism is judicial power, then it was a short ride to saying that CDOs are an exercise of judicial power, even though they create rights and liberties rather than determine existing ones. So the primary question for their honours was whether CDOs offend the Lim principle. I've put that kind of core Lim principle back up there. As I said, it's subject to a lot of exceptions. Those exceptions include mental illness, quarantine, something that everyone is kind of more aware of over the last 12 or so months than ever before here, immigration detention. So lots of kind of exceptions in this growing way. The evolution of this doctrine has prompted different judges at different times to think about reformulating it. Something that maybe unifies a lot of the exemptions, though not all of them, is are they punitive or non-punitive? And then you have Gummo in FARDN, who tries to do away with that punitive, non-punitive distinction in his reformulation that I have to say was resoundingly rejected by the court in this case. So how did their honours deal with Lim in Benbrika? So in the joint judgment, we have a straight, I'd say orthodox, punitive, protective kind of analysis. Are CDOs punitive or are they protective? And they approach that as a black and white kind of distinction. So you've got a quote there from at paragraph 40 of their judgment saying, look, detention in prison is prima facie punitive, yep. But that characterisation may be displaced by an evident non-punitive purpose, which Division 105A has. And that's it. There's a lot more reasoning, but that's basically the core of it. So if you have a legitimate non-punitive purpose that your legislation is directed towards, putting someone in jail for ongoing bouts of 3 years until you decide they're not a risk anymore is not punitive. Now, Justice Edelman engages in a much deeper, I think much more realistic analysis of this punitive, non-punitive distinction. And he classifies CDOs as protective punishment. He says punitive, non-punitive is not black and white, it's a spectrum. And there are things in the middle of that spectrum, like this. This is punishing people to protect other people. What he then does is say, look, those kinds of powers, or this kind of power that we have right here on the spectrum, is exclusively judicial. It has a punitive aspect. It's exclusively judicial. It is judicial power, as exercised in a judicial way. This is fine. So it kind of ignores or reads out the last bit of the Lim principle, that punitive orders can only be made at the end of a criminal trial, basically. He says, no, that's unnecessary. The point is that it's issued by a court, by an orthodox judicial process, and we have that here. So that's how he gets to validity. Our dissenting judgments are much more functionalist. So Justice Gordon starts with the rule of law. Justice Gageler is all about liberty. They go to the separation of powers as the bulwark of liberty, as standing against things like administrative detention, these kinds of exactly what CDOs stand for. So drawing on that kind of value-laden functionalist base, they pair that with another factor in order to find the laws somewhat invalid or wholly invalid. And that's looking closer at part 5.3. So to go back to the other end of my presentation, when these judges look at part 5.3 of the Criminal Code, they found a whole lot of offences that weren't actually that harmful. Possessing a thing in connection with some future terrorist act isn't harming the community. Neither is potentially conspiracy to do an act in preparation. The breadth of these terrorism offences is so vast that it encompasses a whole range of activity that stopping it, and this is how the dissenting judges reason it, stopping that activity is not protecting the community from harm. It's too far removed from the actual harmful bit, the terrorism bit. So by looking closely at part 5.3, Gageler and Gordon go in two separate directions. For Justice Gageler, he says, you could read this down in order to only encompass those harmful offences within part 5.3 of the Criminal Code. For Gordon, she says, look, it says it's protective. When you look deeper, it's stopping a whole bunch of, it's aimed to stop offences that aren't actually causing harm. So it's not rationally connected. There's not a rational connection between the protective object and what's going on here. So the whole thing is invalid. What are the implications of this in my last kind of 50 seconds? There are huge implications, and Felicity is going to dive into a lot of those great constitutional, juicy doctrinal things. To talk a little practically first, though, for terrorism law, I think this gives, or generally, this gives a green light to extended preventive detention by the Commonwealth. There's an example that was obviously came up in argument and was dealt with briefly, or is mentioned by the joint judgment of paragraph 37, which says, well, if you have this community protective purpose, why limit it to offenders? Why limit it to people who are in jail? Why not extend it out to anyone who you find in the community through all of our vast intelligence powers and things, and go, hey, they pose an unacceptable risk of committing an act of terrorism, put them in jail. So it's not a long bow or a long road from one to the other here, I think. In terms of, so that could be a new kind of law. In terms of amendments to existing law, control orders were designed with such care not to involve the incarceration of individuals or detention in a state facility. Potentially, this case drops that limit. That if under a control order it was deemed necessary, reasonably appropriate and adapted for someone to be detained in a state facility to protect the community from terrorism, why not? Equally, PDOs, that 2-day limit, why not? If we've got a green light here for 3 years of incarceration, why not extend that out to a couple of weeks as it's extended out to in the States? So there's a whole range of different implications for terrorism law, and then potentially for other areas of law. And we've seen in numerous ways terrorism law influencing and being copied across to other areas of law, bikie laws in the States, but for the Commonwealth, people smugglers, drug traffickers, who knows what else. So I think this could be the first step or a green light to a lot of policy and law innovation and experimentation when it comes to preventive detention. So at that, I'll hand over to Felicity to talk about the constitutional things, I think.
Okay, so thanks, Beck. That was such just a really wonderful presentation, and I'm really grateful that your presentation was so grounded in the real world, because I'm now going to launch into some fairly esoteric constitutional issues. So in Benbrika, as Beck has been explaining, the High Court was interested in or considering the validity of Commonwealth legislation for providing for preventive detention. And as has also already been pointed out, we already knew that the states could already pass legislation of that kind. And so like a case which is unlikely to tell us anything much about the Kable principle. And indeed, it doesn't tell us anything about what kinds of laws Kable will invalidate. But Benbrika is still interesting from a Kable perspective, and as a state constitutional lawyer, Kable is something I'm particularly interested in. And Benbrika is interesting because it involved a challenge to Commonwealth legislation, which did something we already knew the states could do. It invited the court to consider why and how is the Kable principle any different from separation of powers restrictions, which Chapter 3 imposes on the Commonwealth. So the plurality, this is Chief Justice Kable and Justices Bell, Keane and Stewart, seem to answer that question by posing their own, apparently rhetorical question. Why would restrictions on the Commonwealth be any different? So it was that answer which troubled and confused me, and because to reason that way, as in the states can do it, so why not the Commonwealth, seemed, as Justice Gordon observed in dissent, to invert the accepted doctrine of the court. That accepted doctrine is that Chapter 3 restrictions on the Commonwealth are more stringent than the Kable principle. So a state law will be valid if it passes Commonwealth standards, but the reverse is not true. So this prompted me to reconsider the Rubik's Cube, that is Chapter 3. And although unlike a Rubik's Cube, I remain unconvinced that the riddles of Chapter 3 are capable of logical solution. And I certainly won't be solving any of the riddles in the next 25 minutes, but I do hope to consider some questions. And the two questions that I'm going to explore are really quite basic questions. And they are, first of all, does the Kable principle apply to the conferral of judicial powers? And secondly, if it does apply to judicial power, does the Kable principle apply to the Commonwealth? So before I get into those questions, I just want to briefly explain the background, the constitutional background in Kable's case itself. So the Constitution in section 77(3) permits the Commonwealth to vest federal jurisdiction in state courts. The framers thought this was an expedient solution, freeing the Commonwealth from the necessity of setting up its own separate federal court system. But there is and there remains an important difference between state courts and federal courts. So since Boilermakers in 1956, it's been recognised that federal courts may only exercise judicial power and powers incidental to judicial power. And this, of course, is one of two principles which establish the separation of judicial power at the Commonwealth level. The other being that the judicial power of the Commonwealth may only be vested in Chapter 3 courts. In Boilermakers, the reason why the Constitution separates the judicial power of the Commonwealth from legislative and executive powers was linked to federalism. Because the ultimate responsibility for deciding upon the limits of the respective powers of the Commonwealth and the states rests with the federal judicature, that judicature must remain independent and impartial. So separating the judicial power was a way of maintaining that independence and impartiality. A further justification for the separation of judicial power is, of course, that it's necessary for the protection of individual liberty. So in Benbrika, the plurality said, Chapter 3 courts serve as the bulwark of liberty by virtue of the qualities of independence and impartiality that is secured by the separation of the judicial function from other functions of government. And in their dissenting reasons, Justices Gageler and Gordon also refer to the long history of High Court jurisprudence recognising the liberty-protecting role of Chapter 3. And separately, but relatedly, the separation of powers is also sometimes justified as providing for checks and balances on the exercise of power. But critically, each of these political and philosophical reasons for the separation of powers requires an independent and impartial judiciary. In other words, judicial power is separated to ensure judicial independence, and from judicial independence flows various benefits for the political community. At a state level, however, the position was and remains that the separation of powers does not apply. Hence, state parliaments are free to give their state courts non-judicial power. While the Commonwealth can, of course, confer power on state courts, the Commonwealth can only give those state courts judicial power. And that's why in Benbrika, notwithstanding the power had been conferred on a state court, the question was still one about the separation of powers. So that brings us to Kable's case, which was, of course, like Benbrika, a case about preventive detention. It concerned Mr. Kable, who'd been imprisoned for the manslaughter of his wife and who, while there, had been writing threatening letters to his wife's relatives. So the New South Wales Parliament enacted the Community Protection Act. It famously applied only to Mr. Kable and empowered a court to order that he be detained in prison for a specific period. Now, as you all know, the legislation was invalid. And while each judge in the majority wrote separately, the reasons of Justices Gordon, McHugh and Gummo share a common focus on the constitutional requirement that state Supreme Courts must continue to exist and must continue to exist as fit receptacles for the potential conferral of federal jurisdiction and the separated judicial power of the Commonwealth. For tonight's purposes, I just want to point to a couple of aspects of the reasoning. First, both Justices Gordon and McHugh made the point that state courts are not less worthy recipients of federal jurisdiction than federal courts. So as Justice Gordon said in a passage which gets picked up a lot in later cases, the Constitution does not permit different grades or qualities of justice depending on whether the judicial power is exercised by state courts or federal courts. So it's clear enough that this reasoning assumes that the quality of justice provided in federal courts is protected, at least in part, by the separation of judicial power. There must be something which ensures that state courts meet the same standard. So a new principle was necessary, as Justice Hayden later sarcastically put it, to protect the snow-white purity of federal jurisdiction. Certainly, Justice Gordon was not suggesting that equality might have been produced by a weakening of restrictions at the federal level. Yet in Benbrika, in the pluralities, if it's okay in Farden, why not here reasoning, there is a direct invocation of Justice Gordon's statement about the Constitution not permitting different grades or qualities of justice. The second aspect of the reasoning in Kable is that despite this requirement of equality, the requirements of states were said to be more confined, that is less stringent, than the separation of powers requirements at a Commonwealth level. One reason for that was that state parliaments are still free to confer non-judicial powers on their state courts. And third, the judgments describe the function conferred on the New South Wales Supreme Court by the Community Protection Act as variously not properly characterised as a judicial function, not non-judicial and purely executive in nature. And in this respect, the judgments in Kable drew on what were then recent decisions in Wilson and Grollo, which concerned the conferral of non-judicial functions on a federal court judge acting persona designata. And as Justice McHugh explained in Kable, a state may invest a state court with non-judicial functions, but under the Constitution, the boundary of state legislative power is crossed when the vesting of those functions, read those non-judicial functions, might lead ordinary reasonable members of the public to conclude that the state court as an institution was not free of government influence in administering the judicial functions invested in the court. So it seems to me that statements of this kind reflect an assumption that where a state parliament conferred a judicial power on a state court, questions of incompatibility of the kind which the Kable principle is concerned would not arise. Perhaps it was thought that the vesting of a judicial power is unlikely to be incompatible with the holding of judicial office, or to undermine the independence and impartiality of court. After all, as I noted earlier, protecting independence and impartiality is at the heart of why the Constitution at the federal level requires a separation of powers. So against that background, we'll then move to my first question, which is, does the Kable principle apply to judicial power? So what really prompted me to ask this question was the statement of the plurality in Benbrika, where they said this. They note the absence of the separation of powers under the constitutions of the states, which allows non-judicial functions to be given to state supreme courts. And they say, on the authority of Kable, the conferral of a non-judicial function that undermines the appearance of the independence and impartiality of the court will be beyond legislative power. So against the background of the reasoning I've just described from Kable, that statement seems pretty unremarkable. But it is, in fact, I think, a very curious way of describing the proposition for what Kable stands. And that's for two reasons. The first is that that statement from the plurality in Benbrika departs from what had come to be the seminal statement of the Kable principle adopted in Emerson. The Emerson statement refers to a power or function which substantially impairs a court's institutional integrity. So no distinction is drawn between judicial and non-judicial functions. And this, it had always seemed to me, was consistent with the categorisation of a power as judicial or non-judicial as having no relevance, no constitutional relevance for a state. But secondly, and more significantly, the statement in Benbrika that Kable is an authority about the conferral of non-judicial power seems to actually fly in the face of the High Court's decision in Kable 2. So in that case, the court told us that the power conferred by the Community Protection Act in Kable 1 was actually a judicial power. So Kable 2 came about this way. Following the High Court's decision in Kable 1, Mr. Kable commenced proceedings against New South Wales seeking damages for unlawful imprisonment in respect of the time he had been kept in prison pursuant to an order made under the Community Protection Act. He won in the New South Wales Court of Appeal, but he lost in the High Court. And it mattered for the determination of Mr. Kable's unlawful imprisonment claim whether the exercise of power under the Community Protection Act had been judicial or non-judicial. The High Court held it was judicial, and that the order made by the Supreme Court had therefore authorised his detention, notwithstanding that at the time it was made, notwithstanding it was made under an act which was, of course, at the time invalid. So, importantly, this point about Kable 2 had actually featured quite prominently in the arguments put to the court in Benbrika. So the Commonwealth relied upon Kable 2 to argue that the court had in fact already and unanimously decided that preventative detention powers could be characterised as judicial. So the Commonwealth submissions seemed to boil down to this Commonwealth law does the same thing as the law in Kable 1 and therefore it is valid, which is actually, when you think about it, a pretty strange submission. But in response, the submissions for Mr. Benbrika had attempted to distinguish Cable 2 on the basis that Cable 1 had concerned state and not Commonwealth judicial power, and that the two were different. The Commonwealth had two answers to that. First, the Commonwealth said, in fact, the power exercised in Cable 1 was a Commonwealth judicial power. And that submission was supported in this way. Mr. Kable had challenged the constitutional validity of the Community Protection Act. The Supreme Court was therefore exercising federal jurisdiction. We know, since the High Court's decision in Rezek in 2017, that state laws which confer powers on courts cannot operate of their own force in federal jurisdiction. Instead, such state laws must be picked up and applied by a Commonwealth law, Section 79 of the Judiciary Act. And all of that made the power at issue in Cable not just a judicial power, but in fact a Commonwealth judicial power. Second, the Commonwealth said, even if the Supreme Court in Cable 1 had been exercising a judicial power, it didn't matter because there is no difference between the character of the Commonwealth and of state judicial power. The only difference, the Commonwealth said, is the source of the power. Now, in the end, the plurality in Benbrika simply didn't deal with this submission. They concluded for other reasons that Division 105A validly conferred judicial power, and they said it was therefore unnecessary to consider the Commonwealth submission that Cable 2 was determinative of the issue. On the other hand, Justice Gageler, in his partial dissent, explained that he was not assisted by Cable 2, which he said didn't turn on the proposition that the power to order the continuing detention of Mr. Cable was compatible with Chapter 3. And His Honour noted that precisely the opposite conclusion had been reached in Cable 1. And further, and to return to my question, Justice Gageler expressly described the Cable principle as being capable of being infringed by judicial functions as well as non-judicial functions, and he gave Cable 1 as an example of a judicial function where Cable had applied. So I think the authority of Cable 2 means that there's a lot to be said for the view that the Cable principle does in fact apply to judicial powers. But if it does, then does it follow that Cable or something like it applies to the Commonwealth? In other words, if the conferral of a judicial power on a state court can be incompatible with the court's institutional integrity, doesn't it also follow that the conferral of a judicial power on a federal court could be incompatible with that federal court's institutional integrity? If Cable applies to state judicial powers, and as the Commonwealth said in Benbrika, state and federal judicial power have the same character, why doesn't Cable apply to the Commonwealth? In fact, on the Commonwealth's argument in Benbrika, Cable 1 itself is an example of the Cable principle applying to Commonwealth legislation. And there have been cases where those challenging the validity of Commonwealth legislation have relied explicitly on Cable. So, for example, in 2013, in TCL Air Conditioners and the Judges of the Federal Court, the Commonwealth International Arbitration Act was challenged on the basis that it undermined the institutional integrity of the Federal Court. Justices Hayne, Crennan, Kiefer and Bell skipped what I think are the interesting issues and simply concluded that if it is right to apply directly to a court created by the Federal Parliament, the doctrines enunciated in Cable, there is no distortion of the institutional integrity of the Federal Court, so they went straight to the substance of the argument. The answer, I think, might be that the Cable principle per se does not apply to the Commonwealth, but that Cable-like principles are already built into the Boilermaker's analysis of whether a power is judicial. So process concerns of the kind which, at a state level, are dealt with by Kable can be packed into the characterisation of a power as judicial or not. And Beck touched on some of this in her presentation. But more expressly, in TCL air conditioners, Chief Justice French and Justice Gageler said that the concept of the judicial power of the Commonwealth has various dimensions, and they identified three. The first concerned the nature of the power conferred, and it was this aspect which was at issue in Benbrika. So the argument for invalidity, which picked up on Gummo's analysis in Barden, was that a power to order preventive detention would never come within the judicial power of the Commonwealth. Justice Gummo's view was that the constitutional vice in such legislation was in the nature of the outcome, not the means by which it was obtained. Chief Justice French and Justice Gageler also identified a second dimension, and this concerned the process by which the function is exercised. And this includes things like open and public inquiries and the observance of the rules of natural justice. This aspect of judicial power was considered in some detail by Justice Edelman in Benbrika, but it was interesting to me that in giving examples of laws which would fail on this process aspect of judicial power, his honour cited two Kable cases, Wainahu as an example of a power without a duty to give reasons, and international finance, an example of a law conferring a power to be exercised without key elements of procedural fairness. And then the third dimension of judicial power identified by Chief Justice French and Justice Gageler in TCL air conditioners was this: the overriding necessity for the function always to be compatible with the essential character of a court as an institution, that is, and is seen to be both impartial between the parties and independent of the parties and of other branches of government in the exercise of the decision-making function conferred on it. And this, I would suggest, looks a lot like the Kable principle indeed, an appearance which is underscored by the fact that in support of that proposition, their honours cited South Australia and Tatani, itself, of course, a Kable case. Like Kable, this third dimension looks to and seeks to protect the character of the court as an institution. This third dimension, of course, has a longer pedigree than Tatani. In Lim, the authority which was so central to the questions before the court in Benbrika, it had been said that a law which requires or authorises federal courts to exercise judicial power in a manner which is inconsistent with the essential character of a court or with the nature of judicial power is invalid. But then I wonder, if all of this is packed into the concept of judicial power, why does the conferral of a judicial power on a state court by a state parliament also need to be tested against the Kable principle? So I have three maybe possible answers to this, three thoughts which occurred to me. And the first is this: Kable doesn't need to apply to judicial power, and that's why in Benbrika, Kable is described by the plurality as an authority about non-judicial power. I don't know how to reconcile that position with Kable too. Second, a second possible answer is that maybe when it is said that Kable applies to judicial power, a narrower conception of judicial power is intended to be invoked. Perhaps judicial power here doesn't have the second or third dimensions identified by Chief Justice French and Justice Gageler in TCL air conditioners. That answer sits a little awkwardly with the fact that in Kable 2, an analysis of the procedural aspects of the power reinforced the court's conclusion that the power conferred by the Community Protection Act was judicial. A third possibility, which is related to the second, is that Kable applies to state judicial power because state judicial power is different from and broader than the judicial power of the Commonwealth. This was suggested in submissions by Mr. Benbrika, and it seems to have possibly been accepted by Justice Gordon in dissent. If state judicial power is broader than Commonwealth judicial power, it might make sense and not be a duplication of analysis to ask whether a judicial power is incompatible with the state court's institutional integrity. As a state constitutional lawyer, I find this last answer instinctively appealing, especially if it means that we can do things that the Commonwealth can't do. But I also think that if Commonwealth judicial power will, of course, be narrower than the ordinary conception of judicial power because of the requirement of a matter. But matter requirements aside, I suspect that trying to distinguish concepts of state and Commonwealth judicial power might lead to more subtlety than even Chapter 3 can sustain. So to conclude, ultimately, at a practical level, it doesn't really matter whether Kable applies to judicial powers because the Kable analysis can proceed without first engaging in an analysis of whether the power is judicial or not. But for me, investigating this topic, academic though it might be, is revealing of the interaction between Kable and the separation of powers. And that's a topic of some interest, especially given that Benbrika continues a trend of convergence between those two things. Until Benbrika, this convergence has taken the form of the states being held to standards previously thought applicable only to the Commonwealth. And on that point, I have to stop and note Justice Gageler's dissenting judgment in Vella, which Beck mentioned briefly earlier. So in Vella, Justice Gageler adopted an analysis where he said, it of course goes without saying that a state law meeting Commonwealth standards is valid. But Justice Gageler also said that, in his view, a state law that would fail to meet Commonwealth standards sorry, let me start that again. He also said that if a state law would fail to meet Commonwealth standards, the reasons why it failed to meet those more stringent standards might inform a Kable analysis. And so Justice Gageler's analysis in Vella proceeds as a pure Chapter 3 analysis about the separation of powers. And at the end, he essentially says, for the same reasons, this law fails the Kable principle test. So, and in adopting that test, Justice Gageler again invokes Justice Gordon's essential notion that there be no different grades or qualities of justice. Now, Justice Gageler's approach in Vella, if that were adopted by a majority of the court, would come very close to Boilermakers for the states. His Honour was in dissent, so we're safe for the moment. And in fact, in contrast to his approach in Vella, what we have or seem to have in Benbrika is the first example of the Kable principle appearing to exert some downward force on the restrictions imposed upon the Commonwealth. That's all I've got to say. I think we have time for some questions, if anybody has any.
You can use the chat function.
Oh, yeah. So if you have any questions for either myself or Beck, you can use the chat function, which I believe is somewhere on your screen.
Until somebody has one, I've got a quick question. So first of all, following Benbrika, when would preventative detention cross the line into punitive detention? Can preventative detention ever breach the Chu Kheng Lim principle?
You know, the court always leaves wiggle room, right? There's always a back door. So if you go with just from the majority, our Chief Justice Kable, Bell, Keane and Stewart, if it has a legitimate protective purpose, then that is almost certainly going to displace any punitive actual impact or side purpose or anything that it has. And that the connection between those, like to demonstrate that non-punitive purpose, that protective community protection purpose, And this was, I think, established in the cases leading up to Benbrika as well. It just strengthens this. If you've got a really clear object section and the design of your law is just targeted straight at this is to protect the community from harm or from the commission of offences, either one, apparently, and in making the decision on whether to order this detention, the decision maker will take into account protecting the community or preventing the commission of offences. I think you're going to be pretty right. And the length of these periods of detention is huge. 3 years with the potential for that to just roll on and on. So you'd have to dispel the protective purpose. Yeah.
Okay, I've got an easy question to both of you. Would Cable number 1 be decided the same way today? Now that we've gone through all these sort of shifts in the sand, do you think
I'll leave that to you, Felicity.
Yeah. I mean, in Cable 1, they say you're using the court as an instrument of the executive. That was really the key difficulty with it, is that they saw the court becoming part of an executive plan. And I think that's more plausible where you have legislation aimed at a particular individual. So although we would never say that Cable was invalid because it was ad hominem, I think in a way that ad hominem nature of the legislation did really bolster the executive, making the court an instrument of the executive aspect of it. But I mean, I think if you've got a legislation which applies to all, like DIPSOA, it applies to this huge cohort of people, it's difficult to see it as a legislative plan that all those people will always be kept in prison. And maybe, you know, just thinking off the top of my head, but I think also the availability of those alternative mechanisms means that it is less likely that the court will make an order for imprisonment. So again, so that with DIPSOA you can make other kinds of orders, and that was the same with the Benbrika legislation. I think those alternatives do bolster the validity. But to answer your question, I don't know. Certainly it would have a pretty good chance of being held valid.
I think too they learnt from Kable about the importance of process. So that's where it fell down in international finance. It's where you have all the problems with your control order kind of secret evidence string of cases, the state control order cases, is you really need to strengthen up that judicial process where the judge is independently, not in a rubber stamp way, independently controlling proceedings with a discretion as to how the orders are made, and that really starts to get you into the, well, even if it looks really bad what they're doing it in an independent way that has integrity. So go for it.
And of course, one of the funny things is that one of the judges who had been asked to make an order in respect of Mr. Cable had actually refused. So at least in respect of that event, the executive, the plan to make the court part of the executive had failed there. But
yeah, I've just seen we've got a everyone can see the question. Can you see the question, Felicity? I'm sure.
How about I read it out? It says, I noticed the dissenting judgments in Benbrika refer to the values which underpin the separation of powers, like the protection of liberty when characterising judicial power. I'd be interested in your view of where these values are being sourced from, and whether this suggests that Chapter 3 invites some value judgment / balancing analysis from the court when assessing whether something is judicial power.
So one place the court did look, which I'd tell you, Edward, and anyone else who's listening to go and read, is Ros Dixon's book on Australian constitutional values. It's an edited collection, and James Stelios contributes to that, talking about judicial independence. That book is cited in the judgment a few times, as is Jane Stelios's chapter. So one place they're getting values, which I very selfishly paid attention to, is academic commentary on what are Australian constitutional values. But I think they were not controversial values as well. So the other place where they probably looked more was precedent. So liberty and that idea of the separation of powers as the bulwark of liberty was referred to a lot, particularly by Justice Gageler. And the rule of law is its own wellspring of values that Justice Gordon is referring to quite a lot in her judgments, actually. Felicity, did you want to add to that?
Yeah, I think one of the things which is interesting in the judgments, but which I haven't thought through perhaps as much as I should have, is this idea of the legislation being appropriately tailored to the end. And in fact, Justice Edelman, I think, specifically invokes the idea of structured proportionality as something which can assist in the determination of validity in a Chapter 3 context, which I think previously in Falzon the court had suggested they weren't going to go down the structured proportionality road in Chapter 3, but here we have a situation where they seem to be embracing it in yet another context. So. Yeah,
and not only does Edelman do it, but Justice Gordon does it as well, albeit they're doing it on their own. But her talk of rational connection,
yes,
is very much the same kind of rational connection that's in your structured proportionality. So it's really had a big influence on the court, those structured proportionality cases.
Yeah. Any other questions? I think we're almost out of time. In an event, I might hand back to Patrina.
Well, thank you both very much. Thank you, Rebecca. Thank you, Felicity. That was really very interesting, and I do think it will be interesting to see. Now, it appears that green light is there. How much governments will continue to try to invoke legislation to protect the many, even though it will detrimentally affect the liberty of a few, and perhaps that's why that judicial discretion is so very important, because perhaps that's what's left is that the courts are the only ones who can really be trusted to determine each individual case. So thank you very much. Do we have no other further questions? Perfect. Well, thank you very much for joining us today, and we'll see you at the next event once one is scheduled. Thank you.